We're going live right now with another set of questions for the national exam prep. This one is going to be a total of 33 questions, so it's a shorter one. And let's see what we got going on. So first thing we need for these exam prep questions is scratch paper. There's only 33. Let's knock this out of the ballpark. What happens to a contract if there is undue influence or duress applied to one party of the contract? It becomes unenforceable. It becomes invalid. It becomes voidable. It becomes void. I'm going to go with unenforceable on that one. Unenforceable. What would be the status of ownership if there was joint tenancy made up of 3 people and one of them happens to die? I just took property ownership in this form with 2 other people. I hope I didn't screw this up. The 2 remaining joint tenants now own 1/2 of the property each as joint tenants. The survivors must partition the property and sell it to satisfy the heirs of the deceased. The 2 remaining owners are now tenants in common. The heirs of the deceased inherit the interest in the property. Oh man. So I'm going with the 2 remaining joint tenants now own 1/2 of the property each as joint tenants. Sure hope I got that right. What is the term used to describe the total collection of rights which may be claimed by private ownership? Okay, these are really important things. There's only 33 of them. And if you're taking this because you are setting up a homestead and you want to know how to take title, this is all about you. What is the term used to describe the total collection of rights which may be claimed by private ownership? Freehold, the bundle of rights, the fee simple system, and estate. I believe it's called the bundle of rights. And don't forget that last one. I just did it, and I think I did it right. That 3 of us got together, pooled our money, and bought a piece of land. And we bought it as joint tenants, which the escrow company said they had never done before. The particular escrow person we were working with, because usually people just do it as a fee simple system, I believe. And so it means that if one of us dies, the other 2 just own the property and can move forward. But there is something that says the heirs of the deceased inherit the interest in the property. So perhaps there's something that if you want your portion to go to your heirs, we're going to learn how to do that too. What is the reason why oral contracts for the sale of real property are not necessarily void, but yet are unenforceable? The statute of frauds, the doctrine of lache, the law of agency, the statute of limitations. So what is the reason why oral contracts for the sale of real property are not necessarily void, but yet are unenforceable? Oral contracts. I'm going to go with, it's not the law of agency, obviously. So we have the statute of frauds, the doctrine of lache, and the statute of limitations. I have no idea what this answer is. You go with the doctrine of lache? Sure, that's what we're going to go with. That's what my brother says. If we're going to shoot from the hip, let's be French. What will happen to the easement if Mr. Webster, who was given a life estate, graciously conveys an easement to the Gormans to cross over his land? Ooh, juicy. But he happens to die 1 year after granting the easement. It will remain the Smiths. It will go to Jones's heirs. It will not be enforceable because a life tenant cannot grant an easement without committing waste. It will terminate. I'm going to go with it will terminate. Rough. That's up to your title company. That's why you get title insurance. Which of the following defines a bilateral contract? When one party is given an option to perform, when one party agrees to perform, applies only to leases, when a promise by one party is given in exchange for a promise by another party. That sounds bilateral to me. I know that in a bilateral slash a unilateral contract. At one point, I wanted to change the financing in the middle of a transaction. And so I sent across an addendum saying that I wanted to switch from FHA to conventional for one of my buyers. That is a unilateral change in a bilateral contract. And I can't do a unilateral change. I have to make it a bilateral change so that everybody's in agreement. What type of business organization is formed if 6 individuals unite together to purchase a property and they own the property in severalty? Is that a corporation, a limited partnership, a general partnership, or a syndicate? This is a pretty important one because one of the things about homesteading is you can buy property with other people. What type of business ownership is formed if 6 individuals unite together to purchase a property and they own the property in severalty? I'm going to say a syndicate, but your other choices, if you want to say something different, are a general partnership, a corporation, or a limited partnership. What is the term used when describing the government's right to make laws and regulations for the general welfare of the public? The bundle of rights, escheat, police power, or eminent domain? I'm going to go with eminent domain. What is the term used when describing the government's right to make laws and regulations for the general welfare of the public? My choice is eminent domain. All of the following forms are titles that a husband and wife may hold, with the exception of joint tenancy, severalty, tenancy in common, and tenancy by the entireties. I am going to choose severalty because we said earlier that there was a question about severalty. Let's see it. Well, no. So we'll say severalty. Before a creditor can have his outstanding debt satisfied through the sale of the debtor's property, several legal steps must sometimes be taken. All of the following are steps in the process, with the exception of a writ of persecution. That's what it sounds like, it feels like. A lis pendens, a writ of execution, and a judgment. I'm going to say the process, with the exception of a writ of persecution. Sounds like you're getting persecuted, but I know you put a lis pendens on title when you want to stop somebody from being able to do anything. A judgment, obviously, you put on title to show that somebody owes you money. And a writ of execution sounds like something that a judge is going to do to say, yeah, make this happen. Mr. Harris is married and has children. One day he dies without leaving a will. Oof, rough. The value of his real estate holdings is estimated to be over $1 million. Ooh, just got rougher. What would happen to his real estate? Oh, man. It would be distributed or according to the laws of descent and distribution. It would revert to the state government. It would revert to the United States government. It would be held in trust pending appearance of heirs. Yeah, it's going to be held in trust. They're not just going to take your stuff and divvy it up. That doesn't sound okay. What are telephone lines? But I do have to tell you that I was studying trusts earlier today, and you could fairly easily make your own trust, put all of your assets in the trust so that upon dying, your assets can be distributed to the different people that you've named in the trust. And I believe that that's how you get around a lot of taxes, and you're just kind of moving your stuff around. What are telephone lines an example of? An easement appurtenant, a non-revocable license, an easement in gross, a legally valid encroachment. I believe it's an easement appurtenant. All of the following must be contained in a recorded valid deed, with the exception of a signature of the grantee, a signature of the grantor, an acknowledgement, and a granting clause. I say an acknowledgement. An example of a less than freehold estate is fee simple, determinable, estate in severalty, leasehold estate. An example of a less than freehold estate, I believe, is a leasehold estate because it has a lease. Which of the following covenants is the one where a grantor promises to own a property and has a right to convey title to it? A covenant of quiet enjoyment, covenant of further assurances, covenant of warranty forever, covenant of cession. Which of the following covenants is where a grantor promises to own a property and has a right to convey title to it? I believe it's a covenant of cession. A covenant of quiet enjoyment, I believe, is the right to enjoy your property and all the rights that go with it. Oh, well. A type of tenancy that refers to ownership of real property is called tenancy for years, tenancy at sufferance, tenancy at will, tenancy in common. I'm going to say tenancy in common. A type of tenancy that refers to ownerships of real property is called a tenancy for years, tenancy at sufferance, tenancy at will, or tenancy in common. The following statement is not correct. A deed conveys future interest in real estate if so specified by the grantee. A will conveys no interest in real estate until it is probated. A deed conveys a present interest in real estate. A will conveys no interest in real estate until the death of the testator. I believe the answer that is not correct is a deed conveys a future interest in real estate if so specified by the grantee. I would like to know the answer to that because in my trust, I want to pass my land to my children as a life estate. And if they don't want to enjoy that land, then I want it to go to someone else in my family and kind of just pass around and not get sold. Who is the one that signs a deed to convey property? The grantor, the grantee, any authorized public officer, a notary public only. Okay, so this is it. Is it the grantor or is it the grantee? Who's selling and who's buying? The grantor and the grantee. The executor and the executee. So the executor is the one that takes care of distributing the property after the executee has died. I could say that one. So the grantor, who is the one that signs a deed to convey property? Is it the grantor or is it the grantee? I believe it's the grantee because I believe the grantee is the one getting rid of the property based on that last analysis that I just did as an example of the executor and the executee in the case of a probate. Which of the following would not be covered when determining whether an item is a fixture or not? The value of the item, the intention of the parties when the fixture was installed, the method of attachment, and the adaptation to the real estate. It's the value. The value has nothing to do with whether or not it's a fixture. It's how, if it's screwed in, you just installed part of a property. All of the following are involuntary methods of conveying property with the exception of quitclaim deed, adverse possession, escheat, and condemnation. A quitclaim you deed or you sign. The other ones you did not agree to. Okay, next. What is the primary purpose of a listing agreement? To sell your property. To give the broker permission to sell all of his principal's properties. To serve as a contract of employment between the owner and the broker. to list all improvements and amenities of the property, to serve as a guide for a sales contract. Clearly, the answer is going to be to serve as a contract of employment between the owner and the broker. When is the title to real property conveyed by deed? When it is recorded, when it is recorded by the grantee. That sure sounds like a seller to me. I think we're getting this. When it is delivered and accepted by the grantee. Oh man, now they said the grantee could be the buyer. When it is signed by the grantee and delivered by the grantor, went back to the grantee signing it. When it is signed by the grantor, I think that's the person getting it. So when is the title to real property conveyed by deed? Is it when it is recorded by the grantee? When it is delivered to and accepted by the grantee? No. When it is signed by the grantee and delivered by the grantor? No. When it is signed by the grantor? When it is recorded by the grantee? Typically, the amount of a broker's commission is established by agreement between the broker and the seller or the buyer. Established by the real estate commission, 6% or 7%, based upon standard rates established. It's going to be established by agreement between the broker and the seller or the buyer, and not any of those other ones, because then you're price fixing and collusion and all kinds of problems. Would it be a valid lien if a person builds a hangar next to an adjacent property and a construction lien was then placed against the aircraft? Wow. So would it be a valid lien if a person built a hangar next to an adjacent property and a construction lien was then placed against the aircraft? No, it should have been placed against the real property and the personal property. No, construction lien can only be filed on the real property that was worked on. That sounds true. Yes, the aircraft is more valuable than the hangar. Yes, the aircraft is kept in the hangar. So we're going to have to go with no, a construction lien can only be filed on the real property that was worked on. That question was really poorly written. Would it be a valid lien if a person built a hangar next to an adjacent property? I think they meant to say and did not get paid, and a construction lien was then placed against the aircraft. Oh, yeah, construction liens can only be filed on the real property that was worked on. Absolutely. Otherwise, it was the aircraft, it would be a judgment. Whole different thing. What is a listing broker usually considered to be? A fiduciary agent of the seller. I think in that last section we studied, it said that fiduciary relationships were done away with. A dual agent, the principal in the transaction, the client in the transaction. Nope, guess not. The listing broker is a fiduciary agent of the seller. A blank is an item that has been attached to and became part of the real property, but was originally personal property. Is it going to be an appurtenance, a trade fixture, a fixture, or an emblement? I am going to say a fixture. The interest in a broker's trust account, unless agreed by the parties otherwise, goes to whom? The seller, the buyer, the broker to go toward transaction fees, or the state treasurer. Ooh, commingling. The interest in a broker's trust account, unless otherwise agreed by the parties, goes to whom? Not the buyer, for sure. Not the seller, for sure. And I can't say not the buyer for sure, because if it's over $10,000, then the buyer can get the interest. The broker to go toward transaction fees, or the state treasurer. I think it goes toward the state treasurer. Regarding sub-agency relationships, which of the following is false? A sub-agent has an implied authority to act as a dual agent. No. The selling company should contact the listing company before showing property to a prospect. Oh, so probably it's going to be that first one, because I said no like that, and it's supposed to be false. So regarding sub-agency relationships, which of the following is false? A sub-agent has an implied authority to act as a dual agent. The selling company And that's what I said is false. The selling company should contact the listing company before showing property to a prospect. Absolutely. The listing broker is a principal of the selling broker. The listing broker is a principal of the selling broker. That sounds wrong. A subagent can only perform the activities delegated to him and cannot be involved in making decisions which would directly affect the welfare of the seller. Yeah, that's true. So that's not it. The listing broker is a principal of the selling broker. So which one is false? That one, or a subagent has an implied authority to act as a dual agent, disclosed or undisclosed? I'm going to stick with that. Which of the following statements is false? The director may require the completion of a course of study as a punitive action. Ooh. The director may levy fines as a punitive action. Ooh. The director may revoke or suspend licenses. Ooh. The director cannot proceed with an investigation involving punitive action without a written complaint. No, that doesn't sound right. All exclusive listings must include, I bet it's a legal description, a permission for the listing broker to appoint subagents, a definite date of expiration, an automatic renewal clause, a dragnet clause, a date of expiration is something I always have in mind. The order of water rights is determined by many states according to which users of the water hold a recorded beneficial use permit. What determines this allocation of water rights? The doctrine of prior appropriation, literal theory, riparian theory, accretion. I think it's riparian theory because of riparian rights. If a broker wants to change a flat fee to all sellers, regardless of the list price of a house, in order to collect the same amount for any sale, in what instance could the broker be able to do that? By showing the seller the flat fee versus the percentage of the list price. I don't know if you guys saw that light flicker in my corner. It was like there's a ghost in here. I just got to finish these last two questions and not freak out. I got to start this question again. That was really creepy. I've been watching Ghost Channel all day in the background. If a broker wants to charge a flat fee to all sellers, okay, a flat fee, regardless of the list price of a house, in order to collect the same amount for any sale, okay, I know a broker that does that. In what instance could the broker be able to do that? By showing the seller the flat fee versus the percentage of the list price, by informing the seller prior to the listing and obtaining an agreement, if the broker applies to the state legislature, if there was a history of this in that area. I believe it would be by informing the seller prior to the listing and obtaining an agreement. Which of the following is not a punitive action that is available to the director? What can the guy not do? Or girl? Suspend a license, revoke a license, sentence to jail, or levy a fine. Jail. The director can't send me to jail. All right, let's submit it and see. Ooh, 70% on the money, baby. Okay, so let's see what we got wrong. What happens to a contract if there is undue influence or duress applied to one party? It becomes voidable, not unenforceable. So we need to study unenforceable, voidable, void, and invalid. Okay. Attempts to influence an unwilling or reluctant participation can render the contract void because all parties must enter into a contract willingly and believe that doing so is in their best interest. Next, wrong one. What is the reason why oral contracts for the sale of property are not necessarily void, but yet are unenforceable? That's because of the statute of frauds. So the statute of frauds, the doctrine
of Lache. It was wrong. It was the statute of frauds.
It was a good guess, though.
The law of agency and the statute of limitations. Statute of limitations.
Okay. The next one. What types of business organization is formed if 6 individuals unite together? Oh, man. It's a corporation, not a syndicate.
Corporation is 6 individuals
Purchase. Oh, there's severalty.
6 individuals own a property
In severalty.
That's the important thing that we have to learn. Severalty. What does that even mean?
And the other thing we're going to want to know on that
Is syndicate, because I know a crime syndicate from listening to
Ice-T years ago. Sole ownership is the definition of severalty. Oh, that was easy enough. Got severalty covered. So sole ownership is the definition of severalty. In order for multiple people to create sole ownership of a single property, they must create a corporation. As it is legally known that a corporation is considered to be an individual. Corporation is a person. Like the United States of America is a corporation. I don't know if you're aware of that, but the entire country is a corporation. Heads up. What is the term used when describing the government's right to make laws and regulations for the general welfare of the public? That is called police power, not eminent domain. I wondered, so eminent domain is where they can take your stuff. Police power is when they can make laws for the general welfare of the public. So it says, hold on, and it will tell us what this means. What many people don't realize is that police power is not limited to just criminal law enforcement, but it also refers to all powers of local, state, and federal government to enact and enforce laws for everything from parking to reasons, purposes why people construct buildings. So police power is the government's right to make and enforce rules and laws. That's what I got out of that. Mr. Harris is married and has children. One day he dies without leaving a will. The value of his real estate holdings is estimated to be worth over $1 million. What would happen to his estate? It would be distributed ordered according to the laws of descent and distribution.
Okay, so there's apparently laws of descent and distribution.
Based on a priority of relationships, every state has its own specifications for distributing assets. Usually, first priority is spouse, followed by children, and then other relatives. What are telephone lines an example of? An easement in gross.
Telephone lines are an easement in gross
versus being an easement appurtenant.
So we will need to look up easement appurtenant
to see what that might be. All of the following. Granting a company or individual limited rights to access another's property for a specific purpose, an easement in gross. In this case, would be installing, repairing, and maintaining telephone lines. All of the following must be contained in a recorded valid deed with the exception of a signature by the grantee. All of the following must be contained in a recorded valid deed with the exception of a signature of the grantee. the grantee doesn't have to sign a recorded valid deed. A deed only needs to have been granted, therefore, only that person's signature is required for recording purposes. Who is the one that signs a deed to convey real property? The grantor. The grantor. So the grantor is the seller. The grantee is the receiver. Got it. The order of water rights is determined by many states according to which users of the water hold a recorded beneficial use permit. What determines this allocation of water rights? The doctrine of prior appropriation. So prior appropriation establishes water rights. So the right to use water adjacent to one's property is known as riparian rights. Okay, I was right on that. These rights are most common in sections of the United States where water is abundant. But in places in the U.S. where water is scarcer, a right known as prior appropriation applies. It grants water rights to deflect a specific amount of water from a specific source to irrigate a certain piece of property. Then, based on when the right was first used or applied for, those rights are assigned a priority, usually during the times of peak demand. The oldest claim has the right to get the water first. Oh, so those are California laws right there. So the doctrine of prior appropriation is whoever owned that land first has the most right to the water. And then it all goes downhill from there. And then everybody gets however much water they're going to get to be able to water their crops. And that's it. Go study this for a while. I'll go look up these terms and then we'll try this again in a few minutes. Doing a great job. We're totally going to get a managing broker's license at 9 o'clock tomorrow morning. We got this.